Welcome to the 2020 Virtual Spring Meeting, brought to you as a special edition of Our Curious Amalgam, the American Bar Association Antitrust Law Section's podcast. Virtual Springs Eternal, Friday, April 17th through Friday, May 1st, as we bring to you some of the top programs from the now canceled in-person spring meeting, as well as new hot off-the-press programs discussing the most compelling issues of the day. Be well and enjoy the show.
Hello and welcome to the Virtual Spring Meeting. My name is John Roberti. Today we are delighted once again to present a really great panel. It's The Great Divide, Diverging State-Federal Enforcement, and the panel is presented by the Civil Practice and Procedure, Healthcare and Pharmaceuticals, and State Enforcement Committees. And with me today to provide some context is John Graubert. John is a partner at Covington and formerly served in the General Counsel's office at the FTC. Hi, John.
Hi, John. Thank you.
John, what's today's panel about?
Well, as many, if not most of the listeners are aware, the antitrust enforcement system in the U.S. is a complex multi-player system. We got the federal agencies, the states, and private litigation. And by the way, we're going to talk mostly about the antitrust side these days, but of course there's a similar arrangement on the consumer protection side. But today we're going to focus on the relationship of two of those players, the feds and the states. And I should say this is not a new subject. The section put out a monograph, I believe, in 1988 on this subject, but it's getting a lot of attention lately, for example, from the T-Mobile Sprint matter.
And John, why is this important?
Well, it's very important. We have, of course, a federal system in this country, and the states have a constitutional role and, of course, are provided for in the Clayton Act itself. As it's fashionable these days to always quote Brandeis, he was the one, of course, who said that the states were the laboratories of democracy. So they're part of the picture, and we need to think about their role and how all of these moving parts relate to one another. And also, this is just my view, I think it's very timely to the extent that any of the cracks in this system, if there are any, may also reflect the broader breakdown of consensus about antitrust enforcement in the antitrust community that we're all wrestling with today. So I think it's particularly important at this time to dig into these issues and see if we can bring some perspective and clarity into the discussion and really sort this all out.
And John, what are we hoping to learn today?
Well, let me just start by saying it is a terrific panel. I'm really looking forward to hearing what they have to say on the subject. I would say that we really need to listen closely and look closely at those cases and trends to understand what is really happening in the cases that we think are examples of divergence between the feds and the states. Why is there divergence and what are they diverging about? And then we can assess if there are costs or other problems because of such divergence. And if so, what can be or should be done about those costs and other problems. And I should also say, on the other hand, that understanding where the states have particular unique concerns may also help make such cases less threatening to the system overall. And again, it could suggest ways we might be able to accommodate the interests of all the multiple parties and minimize any adverse effects of multiple proceedings.
John, this is great. Thank you for that. Thank you for that helpful introduction and giving us that context. Will you stick around with me and listen to the panel and then come back at the end and let's talk a little bit about takeaways? Is that okay?
Delighted. Yeah.
Okay. With that, let's send it over to the moderator of today's panel, Melanie A. Melanie, the floor is yours.
Thanks, John. Let's get started. My name is Melanie A, and I'm your moderator today. I'm an Assistant Vice President and Senior Legal Counsel at AT&T Services, Inc., and here with us today are Elinor HOFFMANN, Mike COWIE, Dave GELFAND, and Mandy REEVES. Elinor HOFFMANN is the Acting Antitrust Bureau Chief in the Office of the New York Attorney General. Prior to joining the office, she was a partner in the firm Coderre Brothers, LLP, for 16 years. Elinor was one of the lead lawyers for the states in the T-Mobile Sprint merger challenge from the inception of the investigation through trial. Mike COWIE from Dechert is a former FTC assistant director. He recently acted as the lead on CVS Aetna, in which DOJ and 5 state AG offices aligned on a merger remedy. Dave GELFAND is an antitrust partner at Cleary Gottlieb. From 2013 to 2016, he was the Deputy Assistant Attorney General for Litigation at the Justice Department's Antitrust Division. Relevant to today's discussion, Dave was also one of the lead trial lawyers for T-Mobile in the recent court challenge to its merger with Sprint, which was brought by a group of state AGs led by New York and California. So Mandy Reeves is the litigation and trial partner at Latham and Watkins, where she serves as global chair of the firm's antitrust practice. She formerly worked at the FTC, where she served as attorney advisor to Commissioner Tom Rush. Mandy's practice is a mix of antitrust litigation, conduct, and merger control work, with an emphasis on matters before the FTC and DOJ, and increasingly state AGs. So Mandy, can you kick us off by providing a high-level overview of the roles that the federal enforcers and the state attorneys general play in antitrust enforcement?
Sure, and thanks to the ABA for bringing us together today for this terrific podcast. So if you were to sort of compare and contrast the roles of federal and state antitrust enforcement over the years, you would find that historically, the federal government, and in particular the DOJ and the FTC, have focused more on national antitrust concerns, and the states have tended to focus on more localized antitrust concerns. What's happened more recently over sort of the last, I would say, 5 to 10 years is that, and more recently, there's been a view that antitrust is not maybe doing its job, not being as aggressive as it can be from an antitrust enforcement perspective. And so the states have started to consider whether there is an opportunity for them to fill that void. Now, that might be because of a different view of the proper view of antitrust enforcement and sort of discretionary things. It might also be a product of the fact of where the Supreme Court law has gone and the fact that the state law is able to go perhaps in a different direction. Whatever the cause may be, the states are tending to take a bigger role, whether it's in high-tech, healthcare, or other areas, as we'll discuss, including fast food franchise agreements. The combination of these differing dynamics, both the different laws that the states can enforce and the fact that they may have different enforcement priorities, has led to sort of increasing divergent roles between the federal and the state antitrust enforcers. We can talk more about that today, but that's probably a good place to start.
Great, thanks. And as you mentioned, states can bring antitrust cases under the federal laws and under their state laws. Elinor, what advantages do you see in states bringing cases under state laws instead of federal laws?
Sure. So first of all, thanks to the ABA for putting on this podcast as part of the virtual spring meeting. And I need to just state a brief disclaimer. Anything I say here reflects my own views only and not the views of the Attorney General of New York or anyone else in her office. We can bring, as Mandy alluded to, cases under state law and under federal law. We have powers under the Clayton Act, Section 16, under the Hart-Scott-Rodino Act to bring damage cases, as parents patriae, and we have our own state laws. As a general matter, we tend to bring cases in federal court under federal law. We find that state laws, at least in New York and many other states, with possible exception of California, state antitrust law is not that well developed in the civil area, and we find that federal courts have far more experience and there are strong federal precedents under federal law. In addition, state law generally follows federal law unless there are specific policies, statutes, or precedents to the contrary. For example, many states have Illinois BRIC repealer laws, which enable us to bring cases on behalf of indirect purchasers. But we can do that by filing in federal court under federal law and then bringing a pendent state claim. So that's what we tend to do. There's one pretty big caveat here. Many states, including New York, have criminal powers under their state antitrust laws. Obviously, that's something that we have to do in state court under our state law. So we generally see advantages in filing in federal court because of the lack of development of state law, but we do have state laws, and certainly it's possible that we will be developing those state laws more aggressively in the future.
Great. Dave and Mike, can you provide a brief overview on the state and federal cooperation process? Let's start with you, Dave. What does the process look like at DOJ?
Thank you, Melanie. And let me also join Mandy and Elinor in thanking the ABA for putting on this podcast. And thank you for inviting me. It's a real privilege to be on this panel with all of you folks. Overview of the cooperation process. I spent 3 years at the Justice Department and had the privilege of working with Elinor on certain investigations and many other state attorney general enforcement folks. I think it's an important part of antitrust enforcement that there be good cooperation between the federal enforcement authorities and the states. We got terrific benefits out of it, I know, when I was at DOJ, because you share perspectives, you discuss theories, you share the load on reviewing evidence, and I think it can be a very beneficial thing for antitrust enforcement. At the same time, I think we need to be cautious about situations where the states and the federal enforcement authorities diverge, because it can impose significant burdens on the parties. And I know we're going to talk about that more during the panel.
And Mike, is the process similar at the FTC? How does it work?
It is similar. Just one point I'll add to David's points is that the current FTC chairman, Joe Simons, has indicated interest in working on training programs with the state AGs on hospital mergers and local healthcare provider mergers. Those often raise uniquely local issues, and it's a form of cooperation between the FTC and the state AGs. It's also a recognition that state AGs play a big role in local markets, especially in healthcare.
Recently, Deputy Assistant Attorney General Michael Murray of the Antitrust Division delivered remarks via teleconference to the New York State Bar Association. He characterized certain matters as disagreements or differences between enforcers. Today, we're going to explore matters that can be characterized as disagreements or differences between the federal and state enforcers. Let's start with the United Healthcare Group DaVita consent decrees, which can be characterized as an example of a difference. Mandy, can you provide a brief overview of the United Healthcare Group DaVita cases and consent decree outcomes?
Sure, and just picking up where Michael left off, United Health Group is a healthcare. United Health Group's acquisition of DaVita Medical Group was a healthcare merger. Much of what I'll just briefly discuss is not particularly controversial. It was a merger in which the FTC sought and obtained a consent decree on the basis that United Health Group's acquisition of DaVita Medical Group, and I should note this is not the kidney care side of the business that folks may be familiar with, but the urgent care centers, the surgical centers, and the medical clinics. And the FTC's consent decree was based on the theory that United Health Group's acquisition of DaVita Medical Group would give United an 80% share of the market in the Las Vegas area of managed care provider services to Medicare Advantage insurers. This was a sort of standard horizontal overlap analysis with a local market issue in the Nevada area. Now, the acquisition involved six states. DaVita Medical Group had a presence in California, Colorado, Florida, New Mexico, and Washington, in addition to Nevada. And the consent decree only pertained to Nevada. Importantly, and this is where we start to get into the point of divergence, the consent decree, which was voted out 4-0, Chairman Joe Simons was recused, and we'll come back to that in a moment. But the consent decree also noted that the horizontal remedy, so the divestiture of the Las Vegas area the Las Vegas area clinics to a divestiture buyer, would also resolve a vertical theory. And the vertical theory was that United Health Group would now be the main Medicare Advantage insurer, and now would own a larger share of Medicare provider organizations and could raise rivals' costs and effectively charge more to United Healthcare's competitors. That vertical theory was included in the consent decree as a basis and a justification for seeking the divestiture. Where things get interesting, as they often do, is when you start looking at the FTC statements from the various commissioners. Again, I noted that Commissioner Simons was recused, and there were two statements. So the statement from Commissioner Wilson and Commissioner Phillips took the view that this was a sufficient remedy, and that they had considered whether there was a vertical theory in Colorado, where there was not a basis for a horizontal divestiture, but that they had considered the vertical theory, but that in their view, the risks of litigating that were too great, and that they thought at best the evidence was mixed. Conversely, Commissioners Slaughter and Chopra issued a statement, although I'll note it's not a dissent, but issued a statement saying they would have gone further and sought to block the transaction on the basis that the vertical issue, and again, no horizontal issue, but the vertical issue that remained in Colorado would have had anti-competitive effects. Just as an interesting footnote, it was important that all four ultimately signed on. And as you can see, there was a 2-2 split. One of the sort of interesting things about the FTC that many folks don't realize is it actually takes a vote of 3 to accept a consent decree. And so while Commissioners Wilson and Commissioner Phillips were on board with the consent decree as it was, if neither Chopra nor Slaughter had joined them in accepting the consent decree as it was, there wouldn't have been any consent decree. So the parties effectively would have been able to close without a remedy unless all four could agree on a basis to litigate, which there was obviously division. So in comes the Colorado AG, which did obtain a settlement on the basis of a vertical theory and was able to obtain behavioral remedies. They reached an agreement with United Healthcare where it lifted an exclusive contract with a medical provider in which it agreed to lift that exclusive contract for at least three and a half years, making that medical provider available to other insurers. And then 2, it extended DaVita Medical Group's contract with Humana through the end of at least 2020. So there were differences in the remedies, but there were importantly 2, one at the Colorado level and one at the FTC level, which is highly unusual to say the least in a merger enforcement action, and is a significant development.
And as you mentioned, the Colorado AG intervened in the merger and reached its own settlement rather than signing on to the FTC's consent. So how did the state's perspective differ from the FTC's, and why would Colorado have wanted to negotiate their own consent decree?
And before I keep going, Elinor, did you want to interject?
Yeah. So I just wanted to point out, I think we have to use the word divergence a little bit cautiously. The Colorado AG in that case brought a case in state court in Colorado under Colorado law to deal with the vertical issues that he perceived created a problem in Colorado. In a way, I think this isn't so much divergence as just looking at a problem a little bit differently. As Mandy said, the 2 commissioners who were focused on Nevada issued a statement saying that it was really litigation risk that deterred them from proceeding with the Colorado issue. And the state attorney general in Colorado decided, despite that litigation risk, he would proceed, and he did achieve a settlement, which was, I think, practically concurrent with the FTC settlement. It wasn't much later in any event. Also, there was a statement by Commissioners Slaughter and Chopra, which in essence said, we will sign on to this decree, but we think it's fortunate that the Colorado AG has brought the action, and we encourage state AGs to do their own enforcement of antitrust laws in appropriate circumstance.
And that's actually a great point to pick up on, Elinor, in response to Melanie's question, which was how the state perspective differed from the FTC's perspective. Here I do think one area in which there was perhaps some disagreement might be in the scope of remedies that the FTC was willing to enter into on the vertical side. Now that has waxed and waned over the years, as folks may know, and is a more recent development on the vertical side during the Trump administration, a desire not to seek behavioral remedies in transactions that raise vertical issues. And so it's certainly potentially the case that the fact that was not an option on the table for the FTC opened the door to the Colorado AG to seek a remedy that the parties were willing to enter into in order to close their transaction. And then just a second difference, at the risk of stating the obvious, but I think it's important, particularly when you're dealing with a transaction or anything that's at the FTC versus at the state level. At the FTC, you are dealing with 5 decision makers and a need to get 3. Obviously, at the DOJ, you've got 1, but at the FTC, you need to get 3. And the fact that you need to form a majority can, in many cases, just lead to different outcomes, where at the state level, obviously, there are many decision makers, but it ultimately stops with the AG. So those are other differences that can lead to different outcomes just from a process point.
Mike, another healthcare matter, the CVS-Aetna merger had a different outcome than the United Healthcare Group, DaVita. In CVS-Aetna, the DOJ and 5 states aligned on a merger remedy. Can you tell us about the CVS-Aetna matter and how the case was resolved?
Yeah, so this is an illustration of convergence in contrast to divergence. So CVS Health Aetna was a $70 billion deal. It's the largest healthcare services deal ever, and it's public through Tunney Act filings that DOJ and state AGs investigated 10 different markets. It was very thoroughly investigated. The investigation focused primarily on vertical theories. I was a lead for CVS. I interacted with a number of state AG offices, as well, of course, as DOJ. DOJ ended up taking an enforcement action on a horizontal portion of the deal. It was relatively small amount of business, and it cleared the merger on the vertical theories. State AGs did the same thing, and we did have a unusual Tunney Act proceeding, but one of the positive elements of that is the state AGs as a group. There ended up 5 state AGs joining the enforcement action, filed a brief supporting DOJ and defending the settlement. So a good example of convergence.
You mentioned the Tunney Act proceeding. Something notable about the CVS-Aetna merger was that it was the first matter with live witnesses for the Tunney Act. Can you briefly explain to our listeners what the Tunney Act is? And do you think we should be prepared for in-depth Tunney Act reviews in the future?
So the Tunney Act goes back to the Nixon administration period. There was a concern about corruption at the time, and there was a concern about Justice Department decision making, favoring political campaign contributors and the like. So the idea behind the Tunney Act was to have more visibility and transparency, and have the public have an opportunity to comment on proposed settlements, and to have a judge have an opportunity to weigh in. Okay. In the history of the Tunney Act, there have never been evidentiary hearings in almost every situation. The judges promptly approved the settlement. In CVS-Aetna, our settlement filing was assigned to Judge Leon, who is known in antitrust circles for the AT&T Time Warner decision. Judge Leon took a different approach. He wanted advocacy briefs filed. He wanted live witnesses. He wanted executives to testify. So that's what happened. I personally had a 2-hour direct examination of an economic expert, something unheard of in Tuniac proceedings. So it was unusual. It's hard to say whether that will happen more often in the future, but it certainly is something I think merging parties will have to consider in terms of timing and timetables and the like.
Thanks, Mike. So now we're going to turn to matters that we can characterize as disagreements between the enforcers. We've seen some of these matters highlighted in the antitrust news recently, and these disagreements come in different forms. One example is when the enforcers take different paths and make different conclusions about the competitive effects of a transaction. The Sprint T-Mobile merger highlighted some friction between the DOJ and the state enforcers when a coalition of 13 states, plus the District of Columbia, brought an enforcement action against the parties. Dave, can you provide a brief overview of the T-Mobile Sprint merger?
Yes, I'd be happy to. And just to remind folks, our firm represented T-Mobile and also its major shareholder, Deutsche Telekom, at the case and in the case, and I worked on that matter just in the interest of full disclosure. So the T-Mobile Sprint merger came along at a time when there were two dominant providers of mobile wireless services in the United States, AT&T and Verizon. T-Mobile was a distant number 3, and Sprint was an even more distant number 4. With a declining business. There are a number of other players in this market. There are regional mobile wireless providers. There are players that get access to networks and sell at retail mobile wireless network plans. But in terms of the companies that had a broader national footprint, although Sprint was far from being fully built out across the country. You had 4 players, 2 dominant ones, AT&T and Verizon, and then a distant number 3 and number 4. So the merger really presented a unique opportunity for these two companies, T-Mobile and Sprint, to bring together very complementary assets. They had different portfolios of spectrum, and there was an ability by the company after it merged to put that spectrum together and dramatically increase the capacity of the network, which had a great benefit in terms of lowering cost and bringing more capacity into the market, which we argued successfully would be pro-competitive. For its part, T-Mobile was running up against a wall with its uncarrier strategy, its very aggressive competitive strategy to try to win business from AT&T and Verizon, because it was hitting capacity constraints when it was trying to take on new subscribers. And for its part, Sprint was desperately trying to improve its network, but lacked low-band spectrum that would allow it to do so. So it was in kind of a vicious cycle of trying to bring on new subscribers who would then be dissatisfied with their network experience. And they had no way to improve that because there was a layer of spectrum that they just weren't able to obtain in the market. And it had been 10 years since they won an auction. And so bringing these companies together gave this very unique opportunity to bring improved service to the subscribers who used each of those services. The companies went through a very exhaustive process with the Justice Department and the FCC. They negotiated commitments, including a very substantial divestiture of assets and an entire prepaid business, which is more of a discount business that addresses the discount end of the market. They divested that to Dish, or they agreed to divest it to Dish, and also give Dish the capability of building out its own nationwide network over time, which had an additional benefit of bringing an awful lot of unused spectrum that Dish held into the mobile wireless market. So in addition to this extra capacity that would be obtained by T-Mobile through this merger, you had another player, Dish, bringing even more capacity into the market. And the FCC and the DOJ were both satisfied that those pro-consumer benefits would be accomplished. I should also say there were a number of state AGs who joined the Justice Department in resolving this matter with the parties, and who also saw the benefits to consumers. But there were a group of state AG offices who saw it differently and who brought a case challenging the merger. That case was litigated starting in around June of 2019, and it was tried in December of 2019. And the district court, Judge Marrero in the Southern District of New York, issued his decision in February of 2020 and rejected the challenge. He basically held in favor of the companies on the various points that have been presented at trial about the benefits of the transaction, the fact that it would improve competition, the fact that it would bring additional capacity to the market, lower costs, improve the situation for consumers. He agreed with the defendants that Sprint was in a declining state and was not likely to be as competitive in the future as it had been in the past. And he saw a lot of merit to the remedies that the Justice Department and the FCC had negotiated, and he agreed after hearing evidence from the relevant executives, not just of the companies that were being sued, but also from Dish. Judge Marrero agreed that would bring additional benefits to the market. So he agreed with us and rejected the state's challenge. The states ultimately chose not to appeal, and the merger closed in March of 2020.
Thanks, Dave. And Elinor, do you want to give your take on the merger or respond to Dave?
I don't want to relitigate the merits of the case here. I disagree with a lot of Dave's characterizations of the market and the issues at stake and the merits. But I do want to bring it back to the subject of the podcast here. So I think it's very important here to note how much the states and the DOJ were aligned. So after the extensive investigation that both the states and the DOJ did, the DOJ concluded, and it said so in its complaint filed in the Tunney Act proceeding, that the merger, if consummated, would cause the merged parties to compete less aggressively and make it easier for the three remaining national facilities carriers to coordinate their pricing, promotions, and service offerings, resulting in increased prices and less attractive service offerings for American consumers, who collectively would pay billions of dollars more each year for mobile wireless service. So we and the DOJ were perfectly aligned. The DOJ did not find that the efficiencies outweighed the benefits of the anti-competitive effects of the merger. And the DOJ wasn't convinced that Sprint was a weakened competitor that couldn't compete effectively. The only place where the states and the DOJ diverged was on the perception of Dish as an effective fourth competitor who could step into the shoes of Sprint and restore the competition that was lost because of the merger. And the DOJ concluded that Dish would be able to do that. And they concluded that based on kind of a limited evidence that was available at the time they made that determination. The states were not persuaded by Dish's argument and T-Mobile's argument. And that's why we brought suit and decided to pursue the matter further. Then we did extensive discovery, and we found evidence that, in our view, supported our position that Dish would not be able to restore competition and step into Sprint's shoes. So, as Dave said, the case was tried, but I do want to, make that point that we and the DOJ actually were very aligned on our conclusions regarding the merger as originally proposed. The other thing I'd like to say is that this is a very unusual situation. It probably is the first time in about a half century that the states have pursued a merger of national importance on their own, given a divergent or a different view by the DOJ or the FTC. There have been other situations where states have pursued a different remedy, like in the Valero situation in California, in the American Stores situation a bunch of years back, also in California. But this was an unusual circumstance. The states felt strongly and still feel that we took the right approach in bringing the case. And, it didn't turn out the way we had hoped, but we think we made an impact.
Dave, would you like to respond?
To say that the states were completely aligned with the DOJ except for one issue, when this case resulted in an additional 8 or 9 months of litigation and cost and delay of closing the transaction, really doesn't do justice to the canyon that existed between the DOJ and the states on this case. And the states, in effect, asked Judge Marrero to completely disregard what the DOJ had done, disregard Dish entirely, and act as if that remedy didn't even exist. And the DOJ, for its part, and the FCC, for its part, recognized the tremendous benefit that would come to consumers from getting this deal. So you have two federal agencies who have concluded that this transaction is in the public interest, is going to help consumers, is going to lower their cost, which, by the way, it already has. T-Mobile has already announced significant price cuts on certain plans as a result of being able to do this merger. And you have a group of state AGs who come along and tie the merger up for another 8 or 9 months and delay those consumer benefits from coming to market. That is not a small, insignificant disagreement between the agencies. That is a fundamental disagreement between the states, on the one hand, saying that a federal court should just start from scratch, disregard what the DOJ has done, disregard the views of the expert regulatory agency that sets nationwide telecommunications policy, and give them another bite at the apple. Taken to an extreme, the position that the states took here would give every state in the country a new shot with a blank slate, in effect arguing that the court should presume, not just analyze the merger, taking the federal input into consideration, but presume that the merger violates the antitrust laws, even though the DOJ and the FCC have said it's going to help consumers. So that is not a small difference by any means. And there were other differences, too, other differences in the way the case was pled, other differences in the way the evidence was viewed. This is not a small difference.
Elinor?
Yeah, sure. I didn't say it was a small difference. I said it was the only difference. The only difference was on the Dish remedy. And obviously it was significant because we went to trial. And the DOJ did not. I do want to point out, and maybe I'm moving on to kind of the next question here, but the states, according to the Supreme Court and according to Congress, have an independent obligation as well as right to enforce the antitrust laws. And that's part of the congressional scheme. And it's not an afterthought. The Supreme Court said specifically it's not an afterthought. That's how Congress set it up. So a court's not bound by the DOJ's prosecutorial determination, and it's not bound by what the FCC decides in using its regulatory authorities in the public interest. The states take their enforcement responsibilities very, very seriously. We recognize that what we do can have national implications, not just local implications. And, we evaluated the evidence here very carefully. We made the enormous and unusual and unprecedented commitment of resources to bring this case because we felt very strongly it was in the interest of consumers nationwide.
Thanks, Elinor and Dave. So moving on, earlier, Mike explained what the Tunney Act was, and Elinor, in your response, you mentioned that there was a Tunney Act proceeding in the T-Mobile Sprint merger, and it was notable for an issue around the Tunney Act because the states made a filing in that proceeding to delay any decision until after the trial. Dave, can you elaborate on that filing and the process a little bit here?
Yes. So we did have a settlement with the DOJ and with a number of other states. And we had that proceeding pending, that Tunney Act proceeding pending in parallel with the litigation of the state's challenge. And during the course of that, before we had tried the case against the states came into the Tunney Act proceeding and asked the judge in that proceeding to delay any decision on the Tunney Act review until after the trial was concluded. As I recall, but Elinor will correct me if I'm wrong, part of the point that the states were making there was this is going to be tried in front of Judge Marrero. He will hear evidence. Things will be learned in the course of that trial that could inform the Tunney Act proceeding. This is another danger of having all of these parallel proceedings because you have an orderly process under the Tunney Act when you're trying to get a settlement finalized. And in the case of this particular settlement, certain things needed to wait for final approval before they could start happening in preparation for the remedy, which, as I said, the federal agencies in a number of states all agreed would bring great benefit to consumers. But then you have a small group of states saying, well, wait a minute, hold that up. We're going to go off and litigate. So it not only creates another bite at the apple situation, but it's basically this smaller group of states over here asking to hold up the Tunney Act approval. I think this is a bad precedent. The judge, as I recall, did not rule on that request. He did not rule on the Tunney Act proceeding until after the trial was over. But this is another consequence of having these parallel proceedings.
Elinor, can you share your view on the filings the state made?
Sure. So the states did file what was called an amicus because that's the process that you use in the district court in the District of Columbia. It was a short paper, and we did suggest to the court that it might be the most efficient use of resources of the court to defer a decision until after the trial. The Tunney Act proceeding, in large part, was taking place. Comments were being filed. The comment period went forward. But we did suggest that the judge defer any decision or any hearings, actually, until after the trial. We pointed out that the trial would occur in December and that the parties had agreed, and the defendants had agreed, not to close the merger until 6 days after the final decision by the district court in New York in the merger case. So there would be no delay here. And the Tunney Act proceeding, in any event, doesn't dictate when the deal closes, because the deal can close as it did in CVS Aetna before the Tunney Act proceeding is concluded. So there was no delay here. We just suggested that the court defer its decision until after it had an opportunity to look at the evidence or the district court's opinion in New York. And in fact, I think the Tunney Act court didn't rule until probably sometime within the last month, is my recollection. So it really, of its own volition, delayed its decision. I do want to make one comment. Dave referred to the small group of states that brought the action. It was 13 states in the District of Columbia. Those states represented close to, I think, over 40% of the national population, about half of the urban population, about a third of the rural population, and a much greater number of consumers in the states that ultimately joined the DOJ. So I'll just make that point.
And so both Elinor and Dave touched on this a bit in their responses and comments on the merger. FCC Commissioner Michael O'Reilly said that he was, quote, troubled by what it could mean if the states were to prevail, quote, and he expressed concerns that the states prevailing would hamper M&A in every sector when a state could raise its flag on any particular transaction. Additionally, the DOJ filed a statement of interest on the last day of trial, arguing that, quote, states cannot and should not displace the federal government's role as the nation's federal antitrust enforcer, end quote. The DOJ further stated that when a group of states attempts to do so by seeking relief that quite arguably may benefit certain citizens while harming others, such a remedy is not in the public interest. So Dave, can you share your thoughts on the DOJ's statement of interest here?
Yeah, I think understandably, the DOJ was very concerned that you had a group of states who were delaying and trying to interfere with national telecommunications policy as decided by the Federal Communications Commission and by the DOJ in that investigation. And my recollection is that the statement of interest was filed by both the FCC and the DOJ. But Elinor will correct me if I'm remembering that wrong. It was reported and characterized that the DOJ was in effect saying states should have no ability to challenge mergers. That's not right. They were commenting on the specific circumstances that were before the court, where you had so much of the country that was not challenging the transaction, so many consumers that would benefit from this, and articulation of federal policy by the Federal Communications Commission, and benefits that were being delayed by this action. And as I read the DOJ's and the FCC's statement in our case, it was more about what would be in the public interest in this particular case. Now, I'm going to step away for a minute from the T-Mobile case. We've probably debated it about as much as we can in the context of this podcast between Elinor and me. But there is a serious risk to companies, and it's a problem. If companies can be subjected to a year-long investigation by federal agencies, including a federal antitrust agency and a federal expert agency that sets a policy in a regulated industry, and get through that process and negotiate a resolution, which is always a compromise. It's not an admission that any law was violated. It's a compromise. We'll agree to divest this. We'll agree to do that. There's a serious problem if companies go through that process only to turn around and have any states that decide for whatever reason that they want to start a new process and a new court process. Now, my own view, I'll just state my own view, is that states shouldn't be allowed to do that. And I appreciate that the Supreme Court disagreed with that on existing law, but laws can change. And I think somebody's got to be in charge of the national policy. Like Mike said, the states often have a very unique local issue, if there's something that's unique to the state that needs to be addressed, it ought to be addressed, and it ought to be addressed promptly in parallel with the federal review. But this idea that you go through a federal review and then any state that wants to come along and challenge after that review can then hold it up for another 8 months and maybe create new risk depending upon the tendencies of the judge who they happen to draw in that case. I think that's bad policy. I think it imposes too great a cost on companies that are trying to do very beneficial pro-competitive mergers like T-Mobile is doing here. And I think a serious look ought to be taken at the law in that regard. And I'll make one other point. If we're going to have this parallel review, we really need to rethink the idea that a Philadelphia National Bank presumption can be applied after you've already gone through a year-long investigation, exhaustive investigation, after you have a federal agency like the FCC doing its expert review, thousands of comments, a very lengthy, well thought out decision by the federal expert agency. You have a federal review by an antitrust agency. And then to be able to go to a court and say, well, there ought to be a presumption that those two agencies got it wrong. Forget about the last year's worth of work. We're just going to erase that from memory. And we've got marginally higher market shares than the merger guidelines say creates a presumption. So create a presumption and now make it next to impossible for the defendants to defend their case. Because what the states argued in T-Mobile, and I will come back to our case now, is that efficiency should never be regarded. The Supreme Court has never accepted them. So ignore all of that, Judge. They argued that weakened competitor, as held in General Dynamics, should never be regarded. It's an extreme, rare occasion, unless you have the exact facts from General Dynamics, completely disregard that. And disregard any remedy that the DOJ has entered into. Treat the merger as if we're just doing it from scratch. So after a year and a half of intense investigation, all that work, millions of pages, all this work that's been done, and the very learned decision by the FCC and the very thoughtful conclusion by the DOJ, after all of that, we can come along and just create a presumption, and then there's no defense that's available. And so any of the 50 states get to block the merger after the fact. That's horrible policy. And we need to really think about whether we want to have a system that allows that. I agree with Elinor. This is a rare situation. I don't think it's going to recur very often, but it's a situation that presented itself and demonstrated kind of the absurdity of a system that allows this to happen.
Elinor, can you share your view in response?
Sure. So there's a lot packed into what Dave just said. And among the things packed into what Dave just said is a revision of the Clayton Act and a revision of our system of federalism. And as he mentioned, kind of a reversal of Supreme Court decision-making in the antitrust area. So the Clayton Act, Section 7 says that a merger that substantially reduces competition in any section of the country, in any line of commerce, is unlawful. And that's the law as it stands now. The Supreme Court has said the states have an obligation to enforce that law, and that's what we intend to do until such time as it's changed. I think that we have to recognize that although there's a lot of messiness associated with the system of federalism, there are times, and I think we're experiencing one now, when the states have to perhaps lead in situations where, the federal government may not be adopting policies which the states think are in the best interests of their consumers. So the DOJ filed this statement of interest on the last day of the trial. We responded in I think, an outstanding brief, which was authored by New York's Appeals and Opinions Bureau, which states very succinctly that the states have an obligation to enforce the antitrust laws. It's presumptively in the public interest when the states seek to enforce the antitrust laws. The Second Circuit has said that. The Ninth Circuit has said that. And we're going to continue doing that.
And Mandy, what's your view, either from the perspective of representing a party to a transaction or from a former FTC enforcer?
So I should note that our firm was also involved in T-Mobile Sprint, representing the independent members of the T-Mobile board. I'm just going to briefly comment on a sort of procedural practical issue, which is when companies contemplate any merger, let alone a mega merger, and certainly deals that involve public companies, there is a lot of work that goes into figuring out the timeline, figuring out how long the review will take. There are shareholders, there are companies and banks that have to finance the deal. There are employees that have to stay employed by these companies while the deal is being reviewed. And that process in and of itself puts a tremendous strain on both companies, on the acquirer and the acquiree. And so you need a certain level of predictability to the process. And so when you are in the process of advising a company on whether or not they should pursue a deal that is likely to get a serious look from a federal or a state agency, it is important to have guideposts and expectations for how that process will unfold. Will it take 18 months? Will it take 12 months? Is there a likelihood of litigation? Do you need 24 months? And the sort of disconcerting thing about what happened here and the risk that it puts on the process is one now needs to assume, and perhaps this was an anomaly, but perhaps not, that there remains a risk of a follow-on litigation to block the deal after you go through the process that Dave outlined with the DOJ or with the FTC. And that's tough. And I understand there may be a view that's the company's risk. They assume that when they do a very difficult deal. On the other hand, we do have a system, the HSR Act, that has set out a process. And so, it's hard to know what the new normal is. But I will also say it's very hard to do a deal if it's going to be reviewed for well beyond 18, 24 months. And so it is important to have predictability. And I think what's going on now just calls the process into question in terms of what one can expect.
Mike, same question to you. What's your view?
Mandy hit the key points. I mean, Elinor, has highlighted the reality that, we have a system of federalism. States have statutory powers in this area. They have statutory duties. But just one practical complication, in a lot of these projects, we do have multifaceted parallel reviews. I'm thinking about foreign competition agencies. So you have the US, you might have the EC, you might have South Korea, you might have Brazil. And that needs to be managed carefully. What's tricky with the state AGs is that, they have expertise, they have authority, but we don't, in terms of procedure, there's uncertainty. In other words, it's not a suspensive pre-merger approval process like the Hart-Scott-Rodino Act and like we see in a lot of foreign competition agencies. So I think that contributes to the uncertainty that Mandy highlighted.
Thanks. So I'd like to move on from the T-Mobile Sprint merger and turn to non-merger matters. So disagreements between the DOJ and state attorneys general have not been limited to merger cases. The DOJ and state attorneys general have staked out opposing views on the standard for analyzing no-poach provisions, for example. Mandy, can you give us a summary of some of the various non-poach cases and the positions of the states and the DOJ?
Sure. So how this has evolved over sort of roughly the last decade, it began, as folks may recall, with the DOJ's enforcement action against eBay, Google, and others for agreeing amongst each other that they would not hire each other's employees. The DOJ pursued that per se unlawful. Next, we have the 2016 guidance that comes out of the FTC and DOJ that did make quite a splash, reiterated that these types of agreements would be treated as market division agreements and would be considered per se unlawful and potentially criminal. And the DOJ has subsequently pursued, in the more recent case of Nora Waptak, a consent decree related to a similar agreement in the rail equipment supplier context. So if you sort of look at the DOJ's position, agreements among employers not to poach each other's employees per se unlawful. So now enter some of the more recent enforcement, primarily coming out of the state of Washington, although there has been activity elsewhere, in which franchise agreements for pretty much pick your favorite fast food chain, whether it's McDonald's, Jersey Mike's, Auntie Anne's, Carl Jr., you name it. There have been enforcement actions brought against agreements between franchisors who have agreements with their franchisees not to poach employees of other franchisees of the same franchisor. The state of Washington has, I think, obtained sort of hundreds of resolutions of these agreements and has litigated some as well. And then there have been a wave of follow-on class actions on these as well. And many of those class actions cited the DOJ and FTC's 2016 guidance in an effort to argue that these were per se unlawful. In the context of those litigations, the defendants have said if it's a franchise or franchisee context, that's actually a vertical agreement and should be judged under the rule of reason. And so that issue was in the course of being litigated when the DOJ began to take positions in these cases and intervening and filing statements of interest, taking the position that these agreements should actually be judged in the franchise or franchisee context, also under the rule of reason. And so there has been a split, and the case law is evolving, but there are cases staking out that it's per se, cases taking the position that they should be subject to the rule of reason, and then some saying, quick look. Overwhelmingly, the cases have been settling after the motion to dismiss phase, but there has been a divergence on this point.
Thanks. And you mentioned that some of the cases ended with settlement. So when the DOJ and the states are taking different positions, even if those positions are limited to their respective federal or state claims, do you think a district judge is going to be willing to differentiate the governing legal standards for federal law and state law claims, and why or why not?
So I think there's actually quite a bit to unpack there. I think if the state law simply mirrors the federal law, then I think that the judges are likely to view them in parallel and treat them the same. If there is state case law that is different and you're in more of a Legion RPM setting, then you're going to reach different conclusions. But I think for the most part, what's playing out in the cases, certainly as I've read them, is that the judges are looking at the nature of the agreement. Is it vertical or horizontal? And by vertical, I mean, is it a franchisor agreement? And from that, analyzing whether or not it should be per se rule of reason or truncated rule of reason.
And Mandy also mentioned DOJ's intervention in some of the cases and the 2016 guidance. So DOJ's intervention came as a surprise to many who had been relying on the 2016 guidance issued by the DOJ and FTC, which treated no poach agreements as per se illegal. Mike, does DOJ's position in these no poach cases conflict with the guidance issued by the DOJ and FTC in 2016?
Look, I would just say this is an evolving doctrine and evolving area of law. I expect none of the folks on this call had ever heard of a no poach agreement 10 years ago. And I give DOJ and others credit seeing this as a potential competitive harm. So, instead of viewing this as a conflict, I see it more as a doctrine, an important doctrine that's evolving in real time. It's evolving within the federal system that Elinor mentioned. So I think it's predictable. We'll see some shift in views among the federal agencies and potentially shifting views among the state AGs.
Dave, what's the benefit to DOJ of intervening in state cases or in private litigation?
So when I was at the DOJ, I had the privilege of working with some terrific appellate lawyers there and thinking about when to submit an amicus brief in pending litigation to which the Justice Department was not a party. The Justice Department has played a role in that for decades, probably as long as antitrust enforcement has existed. And the way I think about it is I think there's a very important role for the DOJ to play in weighing in on important issues that could impact the Justice Department's enforcement mission. Law gets developed in the courts, as we all know on this call and podcast, and most of the audience members know. The antitrust laws are relatively short, single-sentence kinds of laws that require 100 years of interpretation, and people still debate what they mean. And how the courts interpret those laws impacts the ability of the Justice Department to carry out its enforcement mission. So if courts are going to start finding that certain types of agreements that there's a federal policy to enforce on are either not unlawful or need to be viewed under a very permissive rule of reason, where the Justice Department feels that the law ought to move in the direction of a per se violation, for example, which I think we see in some of this, then there's an important role for the Justice Department to play. I think it becomes less important when the Justice Department is weighing in on matters that are purely relevant to private enforcement, like class action issues and things like that, which does happen from time to time, or the arbitrability of antitrust claims, for example. Those issues are not so important to federal enforcement, but the DOJ does sometimes weigh into those. The current administration at the Justice Department has made it a priority to be heard on antitrust enforcement matters and wants to file amicus briefs. And I think it's useful when the Justice Department has something important to say, and courts like it. They like to get that input. So I think it's a net positive to the system to have more viewpoints heard.
And Elinor, does DOJ's intervention have repercussions for the states or private litigants who are bringing the cases?
I think it certainly does. A court is not, of course, bound to follow what the DOJ is not bound to adopt the DOJ's position. But the DOJ has a strong and well-deserved reputation as a strong federal enforcer of the antitrust laws. And it does influence, I think, a court. But again, a court is bound to make a determination based on the facts and the law and the case in front of it. And courts have independent obligations.
Thanks. So I'd like to wrap up today's discussion with 3 final questions. Today's discussion provided many examples of disagreements and differences between the federal and state perspectives. Is there a reasonable question about how torn the relationships are between the DOJ, FTC, and the states, or has nothing changed over time in your view? Mandy, can you take that one?
So I'm not going to weigh in on whether it's torn, but I will say that things have changed for sure. You could not have had a podcast like this a decade ago. Or you could, but it would have been way less interesting, which is to say that there has definitely been increased, whether we want to call it disagreement, divergence, split of opinion. There's something going on for sure. You can see it in the disagreements over no poach. You can see it with the disagreements between half of the FTC and the California AG. You can certainly see it with T-Mobile, Sprint, and you can see it in other places too. So I think, at least for now, things have definitely changed. There's two bodies of enforcement, the states, and arguably 50 there, but at least two in terms of the states and the federal government that one needs to keep in mind, and that's in a context in which we already have two federal enforcers. So there's a lot going on, and I don't think we can colorably say that things have not at least changed, because there's definitely a lot of room for disagreement and evidence of that.
And Mike, Dave, you touched on this before, but do you see disadvantages for companies when the state and federal governments are not all on the same page?
Yeah, and I think I've covered it to a fair degree. I will make several points, though. First of all, when you have these kinds of serial challenges or serial reviews to a deal, and by the way, we haven't even talked about private lawsuits against mergers, which provides yet another bite at the apple. But the parties have to run the table. They have to win every step along the way. And anybody who wants to throw themselves in the path of that merger getting done, if anybody, any state AG, any private party wants to file a lawsuit and take another bite at that apple, that creates a big cost and a big delay. And, if you are of the view that mergers are inherently bad and we ought to do everything possible to make sure that we have every chance of stopping them, then you might be of the view that this is a good system. I happen to think a better system is one in which you have very thorough review by a competent authority and get on in life, which itself usually takes a very long time if there are issues. I will say this, and I'm not saying that I'm certainly not saying anything about this with respect to T-Mobile, but there are risks that get introduced when you have too many cooks in the kitchen about how to challenge a merger. There are political issues that could come into play. Maybe there's a political overlay that a state AG's office, which is often political, let's face it, wants to take a different path from the federal authorities for reasons that don't exactly have to do with a careful analysis of the economics of the deal, for example. There are also parochial interests that states have, and we all know this happens. I've seen it happen many times in the course of my career, where states will get a settlement in exchange for a commitment to keep jobs in the state or make sure you keep that headquarters open or something like that. And that introduces a non-antitrust element into this gauntlet that companies have to run. So there are real dangers to having a system where people can keep taking shots and a company that's trying to get a merger done has to run the table from start to finish. Yes, I think the law should be changed. Elinor's right. What I said would require a change in the law, but I think it would be a good thing, and I don't think antitrust enforcement would suffer.
Elinor, do you have a response?
Yeah, I do have a response, and I'll also try and segue into the next question that's coming up. Okay. All right. So first of all, Dave alluded to the problems associated with serial reviews of mergers, and I think Mandy before expressed some concern about the unpredictability of timing when one is advising a firm about a merger, and the element of uncertainty that is increased maybe because of the state's actions. So the first thing I want to say is no one wants serial reviews. The T-Mobile investigation by the states was conducted concurrently with the investigation by the Justice Department. It was not a serial review. What took longer was our decision to litigate, whereas the Justice Department decided to reach a compromise, as Dave mentioned. I do want to make the point that and this kind of goes into the next question that you were going to raise, Melanie, which is firms, to the extent they can, should try and address state concerns concurrently with addressing federal concerns, because that will enable the investigations to proceed concurrently and not serially. It will introduce a measure of predictability. We don't have a Hart-Scott pre-notification act, but we tend to get aware of major mergers very quickly, and sometimes the parties come to us. So we are open to hearing the parties' positions. We have had many presentations by defense counsel in all sorts of cases, merger cases, conduct cases, and we're very, very open to moving quickly, and we can move quickly. And then the last point I want to make is Dave alluded to the dangers of politics interfering in enforcement decisions. I'll just note that we live in an environment where our leadership is political. And that's true both on the state level and on the federal level. And we try and make our enforcement decisions based on the law and the facts and not on politics. But, obviously, I think Dave has a different perception of state enforcement than I do. And I've looked at it from both sides now. So, but we live in a political world for sure, both on the state and the federal level.
And Mike, can you end with providing tips for companies facing multiple investigations?
Yeah, so I would say, the old way to handle these concurrent investigations is you would authorize the FTC or DOJ to share information with the states. And you would have a meeting at the FTC or DOJ, and the states would dial in. And, when you make a submission to the FTC or DOJ, you might send a copy to the state AGs. What we've been doing much more, as Elinor alluded to, is having, advocacy more tailored to the state AGs. So we're going to Elinor's office, or we're going to another state AG office, making presentations directly to them. We're doing white papers that are tailored to the state issues. So, that's a practical dynamic to consider, to not just follow the old approach of just including the states in your federal meetings, but instead consider directing advocacy and engagement directly with the state AGs.
Thanks, and I'd really like to thank Dave, Elinor, Mandy, and Mike for the great discussion today. John, back to you.
Thanks, Melanie. John, what should we take away from today's discussion?
Well, there's a lot of great points made. I would say the following three stand out for me. One, and we're talking mostly about mergers now, petitioners should consider including the states in their overall merger strategy, and particularly with respect to outreach at the beginning of the process, and thinking about when and where to make a presentation and how to identify issues of specific concern to specific states. As some of the panelists, I think Elinor and Mike, acknowledged, that there's no HSR timing available at the state level, but many states have shown a willingness and ability to move quickly. So this is sort of like another angle to multi-jurisdictional merger control. We all have some experience, and we can maybe learn something from the lessons and experience from managing that process and apply it here. My second takeaway is it really is notable that there is a vast area in many cases in which the interests of these parties line up. And maybe, T-Mobile might have been an aberration. We'll see. Of course, we said the same thing about the EU and U.S. divergence on McDonnell Douglas, and then along came GE. So, who knows? Whenever you think something's an aberration, you might get surprised. But it does appear to be a little different than other situations. And finally, and I heard Mandy talk about this, and perhaps David also, we do need to acknowledge that having multiple players in this, particularly in merger control, does add a serious consideration to merger and acquisition analysis generally for companies. It's an additional risk. There's potential additional cost and delay. And, we need to be realistic about that. And especially over the next year or two, as we all try to climb out of our current crisis, this may be a subject requiring everyone's attention.
And John, I think apropos of that comment, look into your crystal ball for us. What do you see? What developments do you see in this area, say in the midterm, in the medium term?
Well, let me just say this. As I was listening to the panel, I was struck a couple of times and reminded of what happens in Europe and the relationship of DG Comp and the national competition authorities in the member states. As you know, in the merger control regulation itself and in other practices, all of these players have established mechanisms for sharing and allocating responsibilities and having cases transferred back and forth depending on, who has a predominant interest in the matter. And I wonder if there are some lessons in that experience for us here in the U.S. About whether or not we could actually put in place better mechanisms for acknowledging who has an interest in a transaction and, giving primary responsibility to one or other players. And, this could happen perhaps through NAG. There's been terrific work in the merger working group in NAG over the years, and they could work together possibly with the federal agencies and try to explore ways to make the system work a little bit more smoothly and minimize conflicts. So I don't know if that's a midterm or a longer term, but that's one thought I had.
John, thank you. Great commentary. Thank you for the context, and thank you for the thoughtful reactions.
It was a pleasure.
Thanks also to Melanie Callis and all of the panelists. Amazing preparation and all the good work. And most importantly, thanks to our members, to you listening, to those of you who are giving us a chance on the virtual spring meeting. We were very grateful that you've joined us. And until we speak again, please be safe and be well.
Thank you for listening to this 2020 Virtual Spring Meeting edition of Our Curious Amalgam. It is produced and shared around the globe by the American Bar Association Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard and would like to become a member of the ABA Antitrust Law Section, visit us at ambar.org/antitrust to learn more. If you have feedback for the podcast or are interested in participating in a future episode, please reach out at ourcuriousamalgam@americanbar.org. Until next time, thank you for listening.